Yes. Other matters. Serial number 5. Here for the petitioner.
Called again. Counsel for the petitioner present. Respondent 2
To MG Kumar for R2 in serial number 5.
The registry has noted that the petitioner has filed affidavit, however, it has written the same with office objection. The counsel for petitioner pays for a week's accommodation to comply office objection. So they copy to other side. Just the matter in the next week.
Number 7. Sri M. Shivprakash for the petitioner. Sri Ilanki Ravi for R2 and 3.
Called again, none appear. Registry has endorsed that the process has been taken at the new address of the unserved respondent. Registry to proceed further in issuing notice.
Number 8. Number 8. Sri Hindu Shekhar Preeti for the petitioner. You may subscribe for the respondent.
Called again, the counsel for the petitioner present. Will be the same order. Yes. The interim order granted earlier is extended by 3 weeks from today.
Sri number 10. Sri Keshamurthy B and N. Sridhar for the petitioner. Abhinay Vaiti for R1 to 3. Entry ಮಾಡಿದ್ರೆ objection ಇತ್ತು. memo for return. For return. Right.
Called again, the counsel for the petitioner and submits that he has taken steps for issuance of notice to unserved respondent number 5. However, a perusal of the order sheet will go to show that long back for more than 3 times the notices, emergent notice sent to the very same respondent number 5 has been returned with the postal shara address he left, close entered comma, once again, no such address he found, close entered comma, once again, no such person in the address. In spite of the same taking the steps to the very same address would serve no purposes. Thus, it clearly go to show that the petitioner, without ascertaining the correct, complete, and present address of unserved respondent number 5, is simply dragging on the matter in the guise of taking fresh steps, even though he is required to make alternate arrangements, like in the guise of taking fresh steps for the improper address, where the address is not, where the R5 is not available. Hence, the petition as against respondent number 5 stands dismissed for not taking steps, for not ensuring the service of notice, not taking appropriate steps and not ensuring the service of notice. Next line. By virtue of the order dated 5/11/2019, since the applicant in IE (1/18) has not completed the office objection, comma, the said IA stands dismissed. Next line. Since the petitioner has engaged the services of the present counsel for him in this matter, the memo filed by the previous counsel and dated 30/10/2021 is allowed, and the learned counsel shown in the memo is permitted to retire from appearing for the petitioner in this matter. Yes.
Number 15. Number 15, Sri Lakshmikant K. The Nagaraj Reddy and pleadings already recorded. SPP for the respondent.
Called in the afternoon, learned counsel for the petitioner and learned HCGP are physically present. At the request of learned HCGP, list this matter on 29/3.
15. Sunil Prasad Pais for the petitioner. Jan Prakash for the respondent.
हाँ Sanat Kumar Shetty has been permitted to retire. Yes. Called again in the afternoon. Learned counsel for the petitioner, learned counsel Sri Sanat Kumar Shetty and learned counsel Sri B.N. Prakash are physically present. Learned counsel Sri B.N. Prakash submits that he has retired in this matter since Sri Sanat Kumar Shetty has filed wakalat for respondents 1 to 4 in re, respondents 1 to 4. He also submits that, however, by some misconception, in the order dated 8/2/2021, it was shown that Sri Sanat Kumar Shetty was retired in the matter, which is not correct. Next line. In the light of the above clarification, learned counsel Sri B.N. Prakash is taken as having retired from appearing for respondent number 1 to 4 in this matter. The registry to scrutiny the Wakalat of Learned Counsel Sri Shanant Kumar Shetty filed for respondent number 1 to 4. And if it is an order, accept the same for respondent number 1 to 4. Yes, you are retired. Yes. ಅದು ಆಟೋಮೆಟಿಕ್ಲಿ ಬರುತ್ತ್ರಿ. ಅಕ್ಸೆಪ್ಟ್ ಒಕ್ಕಾಲತ್ ಅಂದ್ರೆ ಅದು ತಾನಾಗಿನೇ ಬರ್ತದೆ ಮುಂದಿನದು. ಐಗೆ ನಿಮ್ಮದಿಗೆ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆಯೇ? ಇದೆ. Learned counsel for respondent or praise for a short accommodation to file objections to IA 1, 2, and 3 of 2022. A week's time as paid is granted.
Seal number 27. Sri CM Nagbhushan for the petitioner. Amreshwar Pujal for the respondent. Effective.
Yes, please.
Question number 267 of 2015. Their intention that you made an application. Not put up any instruction. You will also get page 50.
Page?
Page 50. For the reason stated in the accompanying affidavit, in place that the Honorable Court will greatly pleased to order to pass an export will be made, restrain depend for putting a temporary and permanent construction on suitable property in the previous and in the interest of justice.
Yes.
A petitioner before lawsuit for the defendants, they filed a written statement containing that there is a sale deed in our favor that is not challenged.
You filed objection to this IA.
Yes, I filed an objection. I have filed a memo stating that my written statement may claim in the objection. They themselves in the debate admit Anuma executed a sale deed in favor of her father, but Anuma never had any right or interest or anything. That sale deed did not be challenged. Revenue record stands in our name. We can draw your lordship attention to page 61, the order of the trial court rejected the application. As an expect, they filed an MA. In MA, the appellate court takes a different view. The trial court finds two things in my favor. It is number one, my sale deed is not challenged. When there is a clause on the title of the plaintiff, mere suit for injunction is not maintainable. That suit should have been not maintainable. Therefore, injunctions are not entitled to the observance. The appellate court also records there is some clause on the title of the plaintiff, but that will not depart the court from granting an injunction. That is what the first appellate court says in the motion. And your lordship will kindly see the prayer in the application is that itself shows they are not in question. It is application prayer is not to interfere with their question. That I should be
Restraint from putting up construction.
Sole construction has been put up a small shop. If I can anything to my learned friend this slide. Very independent is addressing orders. He had a shop. It is a vacant place where we have constructed and one of our brother is carrying it. Now, you know that probably they have to amend the claim, seek for a declaration and prosecution. Read the reasoning of the first appellate court.
Yes, please.
Take number 82.
Yes, please.
And reading from the fourth line.
Yes, please.
In this, it can clearly be believed that during 1944 itself, the plaintiff's father had title and possession in respect of the social property. The possession of the plaintiff's father in respect of the social property was also admitted by Anuma in the case number 95 of 1944-45. If that is so, it is the defendants who have established for the trial court about how the said Anuma got the title in respect of the social property to execute sailing in the name of the defendant. Father subsequently the compromise decree in OS 95 of 1944-45. That is because on perusal of the compromise petition and decree OS number 1944-45, there is no mention that the social property item number 30 and 4 fall into the share of Anuma. Hence, the sale deed relied upon by defense alleged to have executed Anuma to the questionable and doubtful document. That is why the plaintiff in the bench itself has stated that the said vendor of the defendant created the sale deed in the name of the defendant's father. No doubt it is the plaintiff to establish the said aspect at the time of the trial. The court cannot conduct any trial while deciding upon the plan of execution. authorized decree itself clearly speaks about the question of the plaintiff's father. In extradition property, coupled with the other documents, parties taxpayer receives index of land. The question of disbelieving the question of the plaintiff does not arise. Mere dismissal of RRTA appeal by AC is not the definitive proof of document to deny the plaintiff's question. In respect of the suit property, at this stage, because the parties are yet to prove their case before the court at the time of trial. Now, the plaintiff not sought for declaration of safety by anoma in the name of the defendant father, but that itself is not a ground to deny the relief to the plaintiff. At this stage, the court has to balance the documents. What is and we should find out the real act to consider the convenience as well as the individual loss and hardship. The causative parties if the injunction is withheld. Besides this, the photograph available from both theories and shop is constructed. The plaintiff prefers his appeal. This itself is sufficient to hold. The court records that at the time the appeal was filed, the shop is completed. Next is the photograph available for the shop is constructed and completed at the time the plaintiff appellant preferred this appeal. So this is to hold that the defendants subsequent to dismissal application temporary have completed the shop. However, in this regard, the plaintiff is at liberty to get the relief in respect of the said aspect in accordance with law before the trial court if they not in the shop. Further interim relief are granted to avoid. Further interim relief is granted to lawsuit.
Yes.
And para 16 I read for you.
Yes.
The defendants are claiming to question on the basis of the sale deed executed the anoma in favor of defendants of the father during 1960. But as it is already stated, the alleged sale deed executed by her in the name of the defendant father appears to be doubtful document. And there is a clause on the document the sale has to be cleared by defendant themselves at the time of trial. Until then, it cannot be said that the defendants are in question in respect of suit property. Mere production of a revenue document before the court is not sufficient to believe the defendant question in respect of suit property. If the trial court without making the available document before the court properly arrives at a wrong conclusion, the relief of declaration suit of plaintiff is not maintained, which is not proper. It is the operative portion.
Yes.
This is the order passed on 2015 on year number 1. Where and are pertaining to women and cities and boys. The value things for the year set aside. The time this he was heard as recorded in the United himself. Shop is constructed. That's why I brought your lawsuit consideration. What is the prayer in the year number 5 that to describe the different from construction. The construction is over. As the remediate himself finds it. Now the remedy of the plaintiff is to amend it and because there is no reason. The application has exhausted itself. Father of the respondent. Purchased the property and the registered state date with 1 point and the suit. Madama was the owner. He executed the state deed on her behalf as well as her minor daughter. This practice agreed by the petitioner in para number 2 of the petition. This state deed executed by Madama as well as her minor daughter has not been disputed.
No, the present petitioners, that is the defendants, their father Narsimhaya purchased the property by Hanumava
In the year 1960.
in the year 1960.
That is on 22/10/1960. Based on how
Yes.
What was happened, madam? After attaining majority with Hanumamma, she had filed a suit for partition in respect of various properties. In the said suit, item number 13 and 14 are the suit property. In the said suit, Ramaya, son of Timegowda, was also made as a party. Of course, he may be Ramagowda. During the pendency of the said suit matter, the notice was not served to Ramagowda. No notice was served to Ramagowda. During the pendency of the said suit, some of the defendants have tried compromise petitions before the Honorable Court, not to find it.
No, all those points are at the stage of trial. Now, at the outset is, as a plaintiff, how did you secure the property according to you?
We acquired under registered sale,
Executed by?
executed by Gaddamma, herself, and also on behalf of her minor daughter. No. This document is not disputed. And the suit settled property is a vacant site.
1 minute.
After rejecting
One minute, please.
parallel both of the agencies increase and decline.
1 minute, please. So you are the purchaser of the property by the mother. You are the purchaser of the property by the daughter.
He sold his property and then agreed that my window was a mean. So see filed suit.
So the construction of a small shop as shown in the photograph in the petition is not in dispute. Even in miscellaneous appeal also, the said observation is made.
Application under Article 39, June 1 and prior to the reject or mantra. Or computer set for anything. It's nothing but iron box. So vacant iron. So there is in the result, the repetition also clearly stated in paragraph. Repetition clearly stated after dismissal of my IA before the trial, they erected the box. And it submitted that after honorable person being used to dismiss the application. By other date, as the petitioner had made arrangement earlier itself, erected a shop for their use on the scheduled property. And on the certain application.
By looking at the photograph, it cannot be made out whether it is a movable item. The two of the alleged measurement of 10 feet into 15 feet. No, I am telling say it is difficult to notice that it is a movable. May be movable, may not be. By merely looking at a photograph, it cannot be said. ಅಷ್ಟು ದೊಡ್ಡ ಜಾಗ, ಅಷ್ಟು ದೊಡ್ಡ ಬೌಂಡ್ರಿಯಲ್ಲಿ ಈಗ ನಿಮ್ಮ ಪ್ರಕಾರ ಫೋಟೋಗ್ರಾಫ್ ನಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ಸ್ಟ್ರಕ್ಚರ್, ಆ ಬಿಲ್ಡಿಂಗ್ ಸ್ಟ್ರಕ್ಚರ್ ಅದು ಎಷ್ಟು ದೊಡ್ಡದಿರಬಹುದು? ಅದು ಅದ್ರ ಮುಂದೆ ಒಂದು ಬೆಂಚ್ ಇದೆ ನೋಡಿ, ಕಲ್ ಬೆಂಚ್ ಇದೆ ಕುತ್ಕೊಳ್ಳಿಕ್ಕೆ. No, I am referring to this particular photograph at annexure F. That photograph, what you are seeing, probably is not before me in this WP. ನಿಮ್ಮ ಎಡಗೈನಲ್ಲಿರೋ ಫೋಟೋಗ್ರಾಫ್ ಇಲ್ಲ, ನಿಮ್ಮಲ್ಲಿ ಇರೋ ಒರಿಜಿನಲ್ ಅವ್ರಿಗೆ ತೋರಿಸ್ರಿ. ಅನ್ನೆಕ್ಷರ್ ಎಫ್ ಜೆರಾಕ್ಸ್ ಹಾಕಿದ್ದೀರಿ ಅಂತ ಫೋಟೋಗ್ರಾಫ್ ಜೆರಾಕ್ಸ್ ನೋಡ್ಲಿಕ್ಕೆ ಸರಿಯಾಗಿ ಗೊತ್ತಾಗಲ್ಲ. ಅವ್ರ ಫೋಟೋ ಯಾವ್ದು ಅವ್ರು ಹಿಡ್ಕೊಂಡಿದ್ದು ಇಸ್ಕೊಳ್ಳಿ, ಅವತ್ತಿಲ್ರ ಅದಿದೆ, ಅದು ಒರಿಜಿನಲ್ ಸೂಟ್ ಅಲ್ಲೇ ಇದೆ. Both of them maintain status quo with respect to that particular shop till the disposal of the suit, either on maintainability or on merit. So I also record the measurement that the alleged dimension of the shop is 10 into 15 feet, so that by virtue of the status quo order also, he cannot expand the area of the shop. ಹೌದ್ರಿ, ನಾನು ಸ್ಟಾಟಸ್ ಕೋ ಅಂತಿದ್ದೇನೆ. ಹೇಗಿದೆ ಶಾಪು ಅದರಲ್ಲಿ, but it does not mean that if your client has half shaved a person You should retain that person in the same position till the disposal of the suit.
I will not put up on that.
Yes. ಅಲ್ಲ ಅದರಲ್ಲಿ ನಿಮಗೆ ಆಗ್ಬಹುದು, ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಆಗಬಹುದು. ಪಾಯಿಂಟ್ ಎರಡೇ. ಹಾಗೇನಾದ್ರು ಇದ್ರೆ ನೀವು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಯಾವ ವರ್ಷದದು ಸೂಟು? 2015 ಒರಿಜಿನಲ್ ಸೂಟು. 2015 ಡೈರೆಕ್ಷನ್ ಕೊಡುವ ಮೈನ್ ಸೂಟನ್ನೇ ವಿತಿನ್ 8 months ಡಿಸ್ಪೋಸ್ ಮಾಡಿ ಮುಗಿದೋಗ್ತದೆ ಅಷ್ಟೊಳಗೆ. ಅಲ್ಲಿ ನೀವು ನಾನು ಈ ಪಾಯಿಂಟ್ ಯಾವುದು ಹೇಳಲ್ಲ, ಮೇಂಟೈನಬಿಲಿಟಿ ಬಗ್ಗೆ ಏನೂ ಹೇಳಲ್ಲ. ಮೇಂಟೈನಬಿಲಿಟಿ ಆಫ್ ದ ಸೂಟ್ ವೇರ್ ದಿ ಅಲಿಜೆಡ್ ಟೈಟಲ್ ಆಫ್ ದ ಪ್ಲೇಂಟಿಫ್ ಈಸ್ ಕ್ಲೌಡ್ ಅಥವಾ ಸಸ್ಪಿಷನ್, ಅಥವಾ ಮಿಸ್ಲೇನಿಯಸ್ ಅಪೀಲ್ ನಲ್ಲಿ ಡಿಫೆಂಡೆಂಟ್ಸ್ ಟೈಟಲ್ ಇಟ್ ಸೆಲ್ಫ್ ಈಸ್ ಡೌಟ್ಫುಲ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅದು ಎರಡನ್ನೂ ನಾನು not to be considered by the trial court and then the finding of the trial court that will the plaintiff's title is under cloud, the finding of the first the appellate court in the miscellaneous appeal that defendant's defendant title is under suspicious circumstance, both are uncalled for at that stage and held. Avaga that will remain open for you to agitate. Yes, please. ಅದು ಮಾಡೋದು ಬೇಡ, ಅದು ಒಂದು ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿಬಿಡ್ತೇನೆ ನಾನು, ಅವಾಗ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. ಆದ್ರೆ ಇಲ್ಲಿ ಫೋಟೋದಲ್ಲಿ ಕಟ್ಟೆ ಮೇಲೆ ಕೂತಿರೋರನ್ನ ಏಳ್ಸಿ ಕಳಿಸ್ಬೋದು.
ಶಾಪ್ ಕಟ್ಟಿ ಅವ್ರು ನಡೆಸ್ತಾ ಇರ್ಕೊಂಡು ಅವ್ರು ಇನ್ನೊಂದು ಶಾಪ್ ಸಿಮಿಲರ್ ಶಾಪ್ ಇಲ್ಲ ನೀವು ಹೇಳಿದ್ದೀರಾ ಹೇಳಿದ್ದೀರಾ
The present respondent as a plaintiff has instituted a suit against the present petitioners, arraigning them as defendants in OS number 267/2015 in the court of the Principal Civil Judge and JMFC Gubbi Brevity Trial Court for the relief of bare injunction. The suitable property is said to be a landed property measuring 1 gunta. According to plaintiff, the said property was purchased by his father, Sri Ramappa Gowda, alias Ramaya, from one Srimati Doddamma, wife of Huche Gowda, on her behalf and also on behalf of her minor daughter, Hanumama, and a registered sale deed dated 1/5/1942 for valuable consideration. After the death of Ramappa Gowda, the plaintiff as his legal heir has succeeded to the said property. He also succeeded to his property and has got Kata Pahani and got Veda. The Kata and Pahani of this said property were mutated in the name of Ramappa Gowda during his lifetime. It is also the case of the plaintiff that Srimati Hanumama, the daughter of Doddamma, after attaining majority, filed a suit in OS number 95/44-45 against her mother Doddamma and father of the plaintiff, that is I.E. Ramappa Gowda, and others for declaration of title and for recovery of possession of the properties. The said suit is said to have been ended in a compromise between the parties. According to the plaintiff, even under the said compromise, the Hanuma did not got any right title or interest over the suit schedule property. However, the defendants creating a registered sale deed in their favor, the defendants creating a sale deed in favor of their father, and which is shown to have been executed on 22/10/1960, claims the title and possession of the suit schedule property. Alleging that the defendants are interfering in their possession of the property have filed the suit for bare injunction. The defendants entered appearance and filed their written statement and also adopted the same as an objection to the interlocutory application that was filed by the plaintiff under Order 39, Rule 1 and 2 CPC. After hearing both sides, the trial court rejected the said application on the ground that when the plaintiff's title over the property is seriously disputed and doubted by the defendant, the suit for bare injunction was not maintainable. It also suspected the alleged possession of the suit property by the plaintiff. However, in an appeal filed by the plaintiff in MA number 7/2015 in the court of the senior civil judge at Gubbi, the said order of the trial court came to be set aside. And the IA filed by the plaintiff under Order 39, Rule 1 and 2 CPC came to be allowed only on the ground that the documents placed before it creates a doubt about the alleged title of the defendant over the suit schedule property. It is challenging the said order of the appellate court of the Brevity Appellate Court, Senior Civil Judge MA. The defendants in the suit are before this court as petitioners. Learned counsel for the petitioner in his argument vehemently submitted that when the trial court had rightly rejected the application of the plaintiff for the temporary injunction, the trial court the first appellate court observing that there was a cloud over the documents of the defendants and ignoring the fact that the plaintiff's title itself was under cloud, has erroneously set aside the impugned order and granted injunction in favor of the plaintiff. He further submits that the very prayer made in the interlocutory application filed under Order 39, 1 and 2 is only seeking restrainment of the defendant from putting up any construction in the suit property. However, the defendants have already put up a barber shop in the suit property in a small area. As such, they said IA itself has become infectious, and also the prayer in the IA itself go to show that it is the defendants who are in possession of the property. For contra, learned counsel for the respondent submitted that the first appellate court has rightly observed that the defendant's title over the social defendant's alleged title over the social property itself is doubtful, and the plaintiff, by producing the documents, including the sale deed, have shown that they are in possession. As such, the said observation cannot be, as such, the impugned order cannot be interfered with. Next slide. A careful perusal of the order passed both by the trial court and the appellate court would clearly go to show at this stage that, considering the fact that the plaintiff claimed the title through one Srimati Doddamma, and the defendants claimed their title through one Srimati Hanumamma, who is none else than the daughter of said Doddamma. Kama made an observation that the alleged title of the plaintiff under the circumstance of the case was doubtful. As such, a bare suit for injunction was not maintained. On the contrary, the appellate court made an opposite observation, holding that it was the defendant's title that was in cloud. As such, the plaintiff was entitled to for the relief as sought for. It is to be observed at this juncture that merely because the defendant's title is said to be in cloud, that itself ipso facto does not entitle the plaintiff for the relief of temporary injunction. It is for the plaintiff to discharge the burden of proof. It is for the plaintiff to prove that he has been in the lawful possession of the suitable property as on the date of institution of the suit. The alleged weakness, if any, in the case of the opponent cannot be made use of or encashed by the person who approaches the court for the relief in a civil litigation. Since in the instant case, Sapyara, the trial court as well as the appellate court have doubted the alleged title of the plaintiff as well the defendant, respectively, in their orders. And also considering the nature of plaintiff averment, I am of the view that for neither of the courts it was warranted to make any such observation, thus driving the party to agitate on the maintainability of the suit, thus giving a finding regarding the maintainability of the suit as a finality, while disposing of the IE under consideration. Even otherwise also, they had, they were required to go through the pleadings of the parties carefully and parties carefully and could have come to a finding regarding the granting of the temporary injunction or not. At the same time, both the courts should not have lost it the relief sought for in IA under order 30, filed under order 30 in rule 1 and 2 CPC, which was merely for restraining the defendant from putting up any construction in the suitable property. They have not stated that the defendants are interfering in their possession. As such, they must be restrained from interfering in the alleged possession of the property by the plaintiff. Admittedly, during the pendency of the suit, the defendants are said to have put up a small construction in the suitable property measuring 10 feet into 15 feet and is said to be running a barber's shop since October 2015. That being the case, I am of the view that leaving the parties to agitate their entitlement in the original suit suffice it to direct both parties to maintain status quo with respect to social property as on date. Till the disposal of the original suit. Accordingly, the repetition stands partly allowed. The impugned order dated so and so, passed by so and so, stands quashed. However, the observation made both by the trial court as well as the appellate court on the alleged doubtfulness in the title of the parties to the suit also stands quashed. But the question of maintainability of the suit, if required to be agitated by the defendant, is left open to be agitated at the appropriate time in the trial court. With the above observation, modifying the impugned order of the trial court to the extent that both parties shall maintain status quo with respect to the social property as on today, when it is stated that the defendants have put up a shop in the social property as shown in annexure F to this writ petition, and measuring, which is said to be measuring 10 feet into 15 feet, the writ petition stands disposed. Considering the age of the original suit, the early disposal of the original suit in accordance with law, at the earliest, but not later than 8 months from today, by the trial court, is highly appreciated. Both side parties to cooperate with the trial court in that regard. Registry to transmit a copy of this order along with trial court record to the concerned trial court immediately. Yes.
58, Sri K.M. Somsekhar for the petitioner, Sri T.A. Karambaya for the respondent. 38.
Learned counsel for the petitioner alone physically present and prays for a short accommodation. As finally a week's time and spread is granted.
59, Manmohan P.L. for the petitioner. 7. Hegde for the respondent.
Learned counsel from both sides present, as requested by learned counsel for the petitioner, list this matter the week after next, as prayed. The interim order granted earlier is extended by 2 weeks.
Seal number 40, Sri Ravindranath K. for the petitioner, Nagaraj Hegde for the respondent.
Counsel for the petitioner has filed a memo not addressing the writ petition. In view of the memo and supporting submission from both sides, the writ petition stands dismissed as not pressed.
Number 41, Sri Sarath Kumar Shetty K for the petitioner, Joshua A. Samuel for R126.
Then since the matter could not be proceeded.
Number 43, Sarath Kumar K for the petitioner, Sri Basaraj J. Sabrad for R2, H.N. Sunil Kumar for R3, M.S. Saraju for R1.
Same.
Number 44, Sri Kalyan R.
Yes.
Election to declare. He has got 1/3 right in the interstate permit. By virtue of the will executed by part of the plaintiff and defense.
Which of a will?
So far as the execution of the first will by the father is not disputed by the defendant. They admit that in the written statement, Further content that may not be first will executed by the father is subsequently cancelled, and one more will is executed in favor of the defendants. Each one gets half share in that submit. Thereafter the issues were framed. The plaintiff examined himself at KW1, several documents were after class examination, the case was posted for defendant. Defendant led his evidence neither in the written statement nor in the evidence affidavit. Any foundation is laid stating that the cancellation of the will, the original of the will is lost. Subsequently, on 3/7/2017, further examination in chief affidavit was filed. In that, for the first time, say that the cancellation of will is lost. Therefore, the defendant is producing the certified copy of the deed obtained from the service. Marking of that document was opposed by the plaintiff. After hearing the parties, the trial court passed an order permitting the defendant to mark the said document. But during course of the findings, the page number 14, the relevant portion. But the last second parameter, ಉಭಯತರ ವಾದ ವಿವಾದಗಳನ್ನು ಆಲಿಸಲಾಯಿತು. ಈಶಾನ್ಯ D1 ದಾಖಲೆ ದಿನಾಂಕ 7/7/2005 ನೋಂದಣಿ ಆಗಿರುವ ಬಗ್ಗೆ ಈಗಾಗಲೇ ರಚಿಸಿದ್ದು.
ಈಶಾನ್ಯ D1 ಅಂದ್ರೆ ಅದೇನು ವಿಲ್ ಅದು? Exhibit D1 is a will.
And the very same day, there is a cancellation of will.
1 minute.
First will is dated 17/2/2005. Into 2005, first will. Cancellation was on 7/7/2005, as per the written statement. And one more will came to be executed very same. ಒಂದು ದಾಖಲೆ ದಿನಾಂಕ 7/7/2005 ನೋಂದಣಿ ಆಗಿರುವ ಬಗ್ಗೆ ಈಗಾಗಲೇ ಘೋಷಿಸಿದ ಸದರಿ ದಾಖಲೆ ರದ್ದಾಗಿದೆ ಎಂಬ ನಿಲುವನ್ನು ತೋರಿಸುವ ಸಲುವಾಗಿ ರದ್ದಿಯಾತಿ ಪತ್ರ ಹಾಜರು ಮಾಡಿದ್ದು. D1 ಮತ್ತು ರದ್ದಿಯಾತಿ ಪತ್ರ ಎರಡು ದಾಖಲೆಗಳು ಸಾಬೀತುಪಡಿಸುವಂತಹ ದಾಖಲೆಗಳಾಗಿದ್ದು, ಉಭಯತರರ ಮೇಲೂ ಹೊಣೆಗಾರಿಕೆ ಇತ್ತು. ಅಲ್ಲದೆ ಈಶಾನ್ಯ D1 ದಾಖಲೆ ದಾಖಲಾದ ರದ್ದಿ ಪತ್ರ ಸ್ವಯಂಸಕ್ಕೆ ರದ್ದಾದ ಬಗ್ಗೆ ಕಾಣಿಸಿತ್ತು. ರದ್ದಾದ ನಂತರ ಈಶಾನ್ಯ D1 ದಾಖಲೆ ಮಾಡಿರುವ ಬಗ್ಗೆ ಕಂಡು ಬರುತ್ತಿತ್ತು. ಅಲ್ಲದೆ ಸಾಕ್ಷ್ಯ ಅಧಿನಿಯಮ 65 ಯಾವುದೇ ಒಂದು ದಾಖಲೆ ಪ್ರಥಮ ದಾಖಲೆ ಪಠ್ಯದಲ್ಲಿ ದ್ವಿತೀಯ ಸಾಕ್ಷ್ಯದಡಿ ಹಾಜರು ಮಾಡಬಹುದು ಮತ್ತು ಪರಿಗಣಿಸುವಂತಹ ದಾಖಲೆ ಎಂದು ಸ್ಪಷ್ಟೀಕರಿಸಿರುವ ಸಾಕ್ಷಿ ಪ್ರಥಮ ಸಾಕ್ಷ್ಯ ದಾಖಲೆ ಕಳೆದು ಹೋಗಿದೆ ಎಂದು ಗುರುತಿತ್ತು. ಅಲ್ಲದೆ ಈ ದಾವೆಯನ್ನು ಸ್ವಾಧೀನಪಡಿಸಲಿದ್ದು ಸದರಿ ಸ್ವಾಧೀನ ರಸ್ತೆ ಪರ್ಮಿಟ್ ಬಸ್ ಚಾಲನೆ ಮಾಡುವ ಬಗ್ಗೆ ಸಂಬಂಧಿಸಿದ್ದು ದಾಖಲೆ ಗುರುತಿಸಿದ್ದರೂ ಸಹ ಸದರಿ ಬಗ್ಗೆ ಪ್ರಶ್ನೆ ಇರುವ ಕಾರಣ, ಅಲ್ಲದೆ ದಾಖಲೆ ಎರಡನೇ ಸಾಕ್ಷ್ಯ ಆಗಿರುವ ಕಾರಣ ಪಾಟಿಸಲು ಅವಕಾಶ ವಾದಿಗೆ ಸಂಪೂರ್ಣವಾಗಿದ್ದು ದಾಖಲೆಯನ್ನು ಹೊಗೆ ಹಚ್ಚುವ ಅವಕಾಶ ಸಹ ವಾದಿಗೆ ಇರುವ ಕಾರಣ ತಕರಾರನ್ನು ತಳ್ಳಿ ಹಾಕಿ ನಿಶಾನೆ D2 ಎಂದು ಗುರುತಿಸಲಾಗಿದೆ.
Yes.
But the trial court,
Yes.
but while recording a finding commits an error, that exhibit D1 was not cancelled. Cancellation was with respect to will dated 17/2/2005. And the very cancellation was done on 7/7, and the very same day on the 7/7, one more bill came to be. High Court records it finding saying that ವಿಚಾರಣೆ D1 ದಾಖಲೆ ಮಾಡಿರುವ ಬಗ್ಗೆ ಕಂಡು ಬರುತ್ತಿದ್ದು when a bill is disputed, starting up such a finding. Right. The burden is upon the defendant to demonstrate the execution and cancellation of this. Like what says
The defendants contend that it is whose contention that the will dated 17/2/2005 was cancelled.
defendants can.
Defendant's contention. Defendant intended to produce a certified copy of the cancellation deed that you objected to mark it as a secondary evidence. Fine.
Right. Says that burden is upon both the parties. In cancellation, that is not my case.
No. That observation, what is made is only for the limited purpose of whether marking of that said document can be permitted or not. Not beyond that. Not beyond that.
Not the extent of saying that burden is upon both the parties.
That observation is a passing observation.
That would come in the way of the plaintiff's right. And also further says, my lords, prima facie last 2 lines of para 2. ದಾಖಲಾದ ಬಗ್ಗೆ ರದ್ದಾತಿ ಪತ್ರ ಸುವರ್ಣಕ್ಕೆ ರದ್ದಾದ ಬಗ್ಗೆ ಕಾಣಿಸಿತು. ರದ್ದಾದ ನಂತರ ನಿಶಾನೆ D1 ದಾಖಲೆ ಮಾಡಿರುವ ಬಗ್ಗೆ ಕಂಡು ಬರುತ್ತಿತ್ತು. Such observation will not affect the task to the plaintiff.
Where you have stated in your writ petition as a ground that those observation causes prejudice to you. Read it, please.
Defendant in the written statement have admitted the execution of will dated 17/2/2005 and have taken a contention that the will is cancelled by cancellation deed dated 7/7/2005, and on the same day, one more will came to be executed in favor of the defendant. The burden of proving the will and cancellation of the will dated 7/7/2005 is entirely on the defendant. Any will is disputed, burden lies on the parties to prove the same in accordance with section 62 and 65 of the Indian Succession Act. The trial court, ignoring all these aspects, mechanically proceeded to pass an order thereby giving finding holding that it appears will is executed in favor of the defendant after cancellation.
Yes. So you have no grievance for marking that said document as Exhibit D2, but observation made by the court while allowing the marking, you are disputing.
Marking as well as the objection was for marking. There was no any foundation. And also the observation. The para 1 ದಿನಾಂಕ 7/7/2005 ಮರಣಶಾಸನ ಪತ್ರದ ರದ್ದಿಯಾತಿ ಪತ್ರದ ಸ್ವೀಕರಣ ದಾಖಲೆಯನ್ನು ಹಾಜರು ಮಾಡಿತ್ತು. ಸದರಿ ದಾಖಲೆಯನ್ನು ನಿಶಾನೆಯಾಗಿ ರೂಪಿಸಲು ಬರುವುದಿಲ್ಲ ಕಾರಣ ಮೂಲ ದಾಖಲೆ ಹಾಜರು ಮಾಡಿಲ್ಲ ಮತ್ತು ಸದರಿ ದಾಖಲೆ ಬಗ್ಗೆ ಪ್ರತಿವಾದಿಗಳು ಇಷ್ಟದ ಕಾರಣದಲ್ಲಿ ವಿವರಣೆ ನೀಡಿಲ್ಲ ಮತ್ತು ನೀಡಿಲ್ಲ ಎಂದು ವಾದಿ ಪರ ವಕೀಲರಾದ ಶ್ರೀ ಸೋಮೇಶ್ವರ್ ಅವರು ತಕರಾರು ಸಲ್ಲಿಸಿದ್ದು ದಿನಾಂಕ 7/7/2015 ದಾವಾ ಸೂಚಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಈ ಮಾಡಲಾಗಿದೆ ಎಂದು ಸದರಿ ವಿಲ್ಲನ್ನು ಹಾಜರು ಮಾಡುವಂತೆ ವಾದಿ ನ್ಯಾಯಾಲಯದ ನಿರ್ದೇಶನ ಕೂಡ ಅರ್ಜಿ ಸಲ್ಲಿಸಿತು. ಸದರಿ ವಿಲ್ ಪ್ರತಿವಾದಿಗಳ ವಶದಲ್ಲಿದೆ ಎಂದು ತಿಳಿಸಿತು. ನಿರ್ದೇಶನದ ಮೇರೆಗೆ ಸದರಿ ವಿಲ್ ಹಾಜರು ಮಾಡಿದ್ದು ನಿಶಾನೆ D1 ಈಗಾಗಲೇ ಗುರುತಿಸಲಾಗಿದೆ. ಸದರಿ ನಿಶಾನೆ D1 ದಾಖಲೆ ಅದೇ ದಿನ ರದ್ದಾಗಿದೆ. This is a wrong finding. D1 was not cancelled. ರದ್ದಾಗಿದೆ ಅಂತ
ಈ ಒಂದು ಯಾವುದು ಅನ್ನೋದು ನೀವು ಹಾಕಿರೋ ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್ ಇಂದ ಗೊತ್ತಾಗ್ತದೆ? ಸೋ ಅಂಡ್ ಸೋ ಡಾಕ್ಯುಮೆಂಟ್ ಇಸ್ ಮಾರ್ಕೆಡ್ ಆಸ್ ಎಕ್ಸಿಬಿಟ್ D1 ಅನ್ನಂಥದ್ದು ಡಾಕ್ಯುಮೆಂಟ್ ಯಾವ್ದಿದೆ ನೀವು ಹಾಕಿರೋದ್ರಲ್ಲಿ?
And we will not have produced. But it's annexure Gmail, page 39.
So exhibit D1 is bill dated 7/7/2005.
This is not cancelled as per the written statement.
What
the content is on 7/7/2005, a cancellation deed was made. Subsequently, one more bill came to be. Cancellation the first bill is dated 17/2/2005. That bill came to be cancelled according to the defendants. Not at 7/7/2005 bill. This is a ಮರಣ ಶಾಸನ ಪತ್ರದ ರದ್ದಿಯಾಗಿ
Right. The present plaintiff has filed a suit against the present petitioner as a plaintiff in OS number 215/2013. Filed a suit against the present respondents, arraigning them as defendants. The court of the principal civil judge and JMF said Chintamani. For the relief of declaration to declare that plaintiff is entitled to be registered as 1/3 joint permit holder of the suit permit and bus along with the defendants, and also for a consequential relief of perpetual injunction. The defendants contested the matter. At the stage of recording of the evidence of the defendant number 2 as DW1, a document sought to be certified copy of cancellation of a will was sought to be marked, for which the plaintiff raised an objection. Contending that in the absence of there being any foundation laid in the pleading of the defendant, said document cannot be permitted to be marked as an exhibit, even as a secondary evidence. The trial court, by giving reason, overruled the said objection and proceeded to mark the said certified copy of the cancellation of a will dated 7/7/2005 as exhibited D2. Agreed by the same, the plaintiff is before this court through this petition. Learned counsel for the petitioner in his argument submitted that to mark the certified copy of the alleged cancellation of the will, the defendant ought to have laid foundation in his pleading, which he has not done. Further, while overruling the objection raised by the plaintiff for marking the said document, the trial court has made certain unwarranted observation, casting the burden of proving the deed of cancellation also upon the plaintiff. And further, it confused that the alleged cancellation deed was with respect to the alleged second will dated 7/7/2005, which was also not correct. This is submitted that the said order thus does not sustain in the eye of law. The counsel for the respondent have remained. The respondents, though have served, have remained unrepresented. Next. A perusal of the impugned order, which is the observation made by the trial court in the deposition sheet of DW1, to go to show that the learned counsel for the plaintiff raised an objection for recording a certified copy of the alleged, a certified copy which is alleged to be either the registered cancellation deed alleged to be a registered deed of cancellation of a will, capital Annexure H, contending that it is only certified copy and that no foundation was laid for leading secondary evidence. The trial court, observing that the said deed of cancellation was with respect to Exhibit D1, which was the alleged second will dated 7/7/2005, and that proving exhibit D1 as well the cancellation deed, or the documents which requires the proof of the same, and the said responsibility and said burden of proving is on both the parties, proceeded to permit the marking of the said document. In the process, it also made an observation that the DW1 has stated that the original of the cancellation deed since has been lost, he is producing the certified copy. However, the plaintiff in the cross-examination of the said witness can meet those statements, can contradict those statements. He will be a sentence. So also made an observation of the plaintiff Mudin Hurda. The plaintiff have the opportunity to cross-examine the witness on the said aspect. Full stop. To contradict the other better. Yes, please.
Further, High Court observes that possession is not sought.
Yes, kindly don't interfere. Yes. It is me who is the author of the judgment. Yes. Those are all unnecessary things. Even the confusion regarding the date was also uncalled for. Since you said, say, I entertained it. Only gist is that the burden of proof and whether secondary evidence can be marked, can be entertained. That is all. ಸ್ವಾಧೀನ ಕೋರಿ ಸಲ್ಲಿಸಿದ್ದು ಮತ್ತೊಂದು ಬರೋಲ್ಲ. ಅವ್ರು ಹೇಳಿದ ಮಾತ್ರಕ್ಕೆ ಅದು ಬರ್ಲಿಕ್ಕೆ ಸಾಧ್ಯನೂ ಇಲ್ಲ. ಪಾಸಿಂಗ್ ರಿಮಾರ್ಕ್ ನೆಲ್ಲ ನೀವು ಜುಡಿಷಿಯಲ್ ಫೈಂಡಿಂಗ್ ಅಂತ ಹೇಳಿ ಮಿಸ್ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಬೇಡಿ. ಸರ್, ನಮ್ಮ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ಗಳು ಮುನ್ಸಿಫ್ಗಳು ಆ ಪಾರ್ಟಿ ಬೇಜವಾಬ್ದಾರಿಯಿಂದ ಇರಲ್ಲ. ಕೈಂಡ್ಲಿ ಡೋಂಟ್ ಅಂಡರ್ ಎಸ್ಟಿಮೇಟ್ ಅವರ್ ಜುಡಿಷಿಯಲ್ ಆಫೀಸರ್ ಟು ಸಚ್ ಎ ಲೆವೆಲ್. ವಾಟ್ ಈಸ್ ದಿ ಪಾಸಿಂಗ್ ಅಬ್ಸರ್ವೇಷನ್, ವಾಟ್ ಈಸ್ ದಿ ಫೈಂಡಿಂಗ್, ಆ ಬೇಸಿಕ್ ಡಿಫರೆನ್ಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರದೆ ಹೋದ್ರೆ, ಗೊತ್ತಾಗದೆ ಹೋದ್ರೆ ಹಿ ಇಸ್ ಅನ್ಫಿಟ್ ಟು ಬಿ ಎ ಜುಡಿಷಿಯಲ್ ಆಫೀಸರ್. ಅದು ನಿಮಗಿರ್ತಕ್ಕಂತಹ ಡೌಟು, ನಿಮಗೆ ಅರ್ಥ ಆಗದೆ ಇರಬಹುದು. ಫಾರ್ ಮೈ ಬ್ರದರ್ ಜಡ್ಜಸ್ ಇನ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ದೇ ವಿಲ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ಅದು ಯಾವ ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅದನ್ನ ಹೇಳ್ತಿದ್ದೇನಲ್ಲ ನಾನು. ಎಸ್ ಪ್ಲೀಸ್. Yes. While proceeding to permit marking of the alleged cancellation of the alleged deed of cancellation of will as exhibit D2, the trial court has confused that the alleged cancellation is with respect to exhibit D1, which is the alleged second will dated 7/7/2005. Since it is purely a confusion on the part of the trial court without affecting its final finding regarding marking of the certified copy, the said observation, which is a passing observation, shall not in any manner influence the appreciation of the evidence, both oral and documentary, by the trial court at the stage of a final hearing. The other observation of the trial court that Exhibit D1 and the alleged deed of cancellation, since are required to be proved, the said burden of proof is on both the parties is also appears to be an erroneous finding. Erroneous finding to the extent of the place of burden, the erroneous erroneous finding regarding the erroneous finding to the extent of casting the burden upon the plaintiff of proving those documents. As such, the said finding regarding the burden of proof of the said document would also unwarranted, would also being erroneous, would not influence the appreciation of evidence, both oral and documentary, at the stage of the argument and disposal of the suit. However, so far as permitting DW1 to present certified copy of the alleged cancellation deed of the alleged deed of cancellation of will and marking it as Exhibit D2 is concerned, though the defendant is said to have not taken such a specific plea in his written statement, but since he has stated about the loss of the original of the said document in his evidence, and the plaintiff would have every opportunity to confront and contradict DW1 on the said aspect and thus demolish the alleged foundation of the secondary evidence, the trial court's permission to mark the said document as Exhibit D2 shall not be found fault with. It is observing accordingly, the repetition stands disposed of. ಅದು ಎವಿಡೆನ್ಸ್ ಪಾರ್ಟ್ ಅಲ್ವೇನ್ರಿ?
ಫರ್ದರ್ ಎವಿಡೆನ್ಸ್
ಅದು ಎವಿಡೆನ್ಸ್ ಪಾರ್ಟ್ ಅಲ್ವೇನ್ರಿ? ಎವಿಡೆನ್ಸ್ ಫರ್ದರ್ ಎವಿಡೆನ್ಸ್ ಬೇರೆ ಬೇರೆ ಕಾನ್ಸೆಪ್ಟ್ ಏನ್ರಿ? ಎಸ್, ನೆಕ್ಸ್ಟ್.
Number 45, Sri Sami Rasim for the petitioner. Kamleshwar Pujari for R1. Out is served.
None appear in this matter. The perusal of the order sheet would go to show that on previous two consecutive dates of hearing, that was on 15/2/2022 and 4/3/2022 also, none appeared in this matter. As such, it can be inferred that the petitioner is not interested in proceeding with the matter. Accordingly, the writ petition stands dismissed for non-prosecution.
Number 46, Sri Devraj Ji for the petitioner. Deepak Ji for R1.
Is this the matter of dispute between father and son? Good.
I'm very clear.
Ah.
ಇಂಟೆನ್ಷನ್ ಮಗನಿಗೆ ದುಡ್ಡು ಬೇಕು ಅಂದಾಗ ನನ್ನ ಹತ್ರ ದುಡ್ಡು ಬಂದ್ಬೇಕು ಅಂದಾಗ 3 ಲಕ್ಷ ರೂಪಾಯಿ ನಾನು ಕಾಸು ಕೊಟ್ಟೆ. 2012 ವ್ಯಾಪಾರನ ಶುರು ಮಾಡಿ ಸೂಟ್ ಹಾಕಿದ್ರು in respect of the property. They filed a written statement saying, my lord, sir, release date ಮಾಡ್ಕೊಟ್ಟಿದ್ಯಪ್ಪ, ನಾಟೆನಿ ಸೂಟ್ ಹಾಕ್ತೀನಿ ಅಂತ ನನಗೆ.
Suit is filed by your son for
partition and declared that the gift deed executed on 10/6/2002 is not binding on the plaintiff. He had released two items of the property, item number 1 and 2. But I entered appearance, filed my detailed written statement. In para 10 of my written statement, my lords, which is a page number 24, my lords. Ali, ನಾನು ಅಪಿಯರ್ ಆಗಿ ಇಲ್ಲಪ್ಪ ನೀವು ಸರ್ವಿಸ್ ಆಫೀಸ್ ಬಂದು ಇವಾಗ ಎಕ್ಸಿಕ್ಯೂಟೆಡ್ ರಿಜಿಸ್ಟರ್ sorry, release date in my favor in respect of item number 2 is concerned. By taking a sum of 3,50,000, there is a difference what I have taken.
1 minute.
Please.
You are challenging the allowing of the amendment application filed by your son.
Yes, yes.
Where is that application?
Lords, this is page number, my lords, 36, my lords.
42.
Please. My lords, page number 37, the affidavit, my lords. Totally bond.
I come on. Wait a minute.
Sorry.
It is you who in your written statement has taken a contention of the alleged relinquishment deed, right?
Para number 9, page number 24, my lords, para number 13. After noting this, the issue has been framed by shifting the burden on my shoulder, whether the different proofs that the plaintiff has executed a relinquishment deed in favor of so and so. One of the issues has been laid on my shoulder. After the matter has been posted for plaintiff evidence, my lords, he comes up with his application. My lords, in the affidavit, but as per the order 1670, but detailed explanations, my lords, giving in reasoning, my lords, why he has not filed an application within a prescribed time or prior to the trial is concerned. Affidavit, if my lords comes to please to the page number 37 of the my petition, my lords, para number 4. Except these 3 statements, my lords, he has not given any reasoning. I state that after filing the written statement, they have stated they have executed a reasoning in favor of the different number 59/2012, but receiving 3,50,000. All these allegations are utterly false and statements, so on so on. But the trial court, my lords, has framed an issue shifting the burden on my shoulder. But if my lords come to the prayer column of the blame, my lord, he challenges the gift deed.
Where is the issues?
I misplaced the issues, my lord. Issue number 4 is because today morning when I was just.
You have not produced the copy of the issue as an annexure.
Somehow I misplaced it, my lord. Issue number 4 is the burden on me that the different proofs that the plaintiff has executed a relinquishment deed and dated so on so on. Because when the burden is shifting on my shoulder, because I have taken that responsibility, saying that my lord, the plaintiff has executed a release date. But coming up with an amendment application, my lords, after the trial has commenced, it is sustainable. Second point is, my lords,
no, how it prejudices your interest. Fine.
Correct.
It is after you filing the written statement, he has come up with the plea of amendment. In fact, that amendment of the pleading is something like a reply to one of the averment made in your written statement. He had other remedy to bring the same on record. On order 8 rule 9. He did not encash that. But probably he was advised, best advised by his counsel to apply for amendment of plaint only. So he could have quoted it order 8 rule 9. That could have been balanced to the thing. But for the very same thing, he has mentioned it as order 6 rule 17.
Return statement because item number 2 is the property of my wife. This is a suit for partition. It is a self-acquired property of my wife. Then also, my lords, it doesn't have the case on the main relief. Lords, I'm not shifting the burden. None of the shame. 2012, when my father executed a gift deed in favor of respondent number 5, he challenges gift deed. He is not a party to the gift deed, but still he challenges. Relinquishment deed, he doesn't whisper anything in the client. My lords, please.
You are repeating the very same point. He received 3.5 lakh rupees, executed the deed. So that is a disputed fact. Point is very simple. You forget about the other thing.
Please.
Your alleged release deed is a disputed fact.
Please.
That alleged fact was brought before the court in the form of pleading for the first time by you, the defendant, in your written statement. Therefore, the plaintiff had no opportunity to meet the said averment. In such a situation, though he could have invoked a relevant provision under order 8, he invoked order 6 rule 17. Rightly or wrongly, that amendment is now allowed. How that causes any prejudice to you? You have taken a contention that he has executed release deed. Irrespective of his proposed amendment, which is now permitted to be carried out, that burden remains fastened to you only. The burden won't shift. Burden would not vary. Burden would not diminish. In such an event,
what he would have stated under Order 8, Rule 9, or in your cross-examination, he has putting it in the form of pleading. It in no way, except an unnecessary application to Order 6, it makes no difference. No harm would be caused, no prejudice would be caused, no variation in the interest or the opportunity at either of the party would be affected.
Either if the plaintiff has taken the pleading or the defendant, the burden would have shifted either the parties. If the plaintiff has set up that claim saying that my lords are not executed, then the burden would have been on the plaintiff. Now already I have set up a defense in my written statement saying that this is what happened. Issues has been brought to that extent saying that whether the defendant proves so and so, so and so. Not whether that pleading, what I have been set up in my written statement, by virtue of this amendment, my lords, whether the burden can be shifted on the plaintiff, that is one first point.
Burden won't shift. The issue remains as it is. Issue remains as it is, burden also won't shift. That's what I have been
And that
bringing to your notice. Because it is your pleading, your averment. You are contending that there is a release deed executed by king in favor of the defendant.
We have gone to an extent of challenging the releases, saying that my lords, I was not present at all. But in the application itself, he has admitted that I have been to the sub-registry office. But it's his own contention. If he has been to the sub-registry office, my lord, he would have stated in the plain saying that, how the sub-registry office ಹೋಗಿದೆ ಏನ್ ಸೈನ್ ಹಾಕಿದ್ದಾರೆ ನನಗೆ ಗೊತ್ತಿರಲಿಲ್ಲ ಅಂತಾದ್ರೂ ಹೇಳ್ಬೋದಾಗಿದೆ.
ಅಲ್ಲ ರೀ, ಅವರದ್ದು ಸೂಟು ಪಾರ್ಟಿಷನ್. ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಆಫೀಸ್ ಹೋದೆ, ಈಗ ಅವರು ಪ್ರಪೋಸ್ಡ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ದಾರೆ, ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಆಫೀಸಿಗೆ ಹೋದೆ, ಅಲ್ಲಿ ಕೆಲವು ಡಾಕ್ಯುಮೆಂಟ್ ನಾನು ಫೋಟೋ ತೆಗೆದ್ರು, ನಂದೊಂದು ಸಿಗ್ನೇಚರ್ ತಗೊಂಡ್ರು, ಅದೇನು ಡಾಕ್ಯುಮೆಂಟ್ ಅಂತ ನಾನು ಓದ್ಲಿಕ್ಕೂ ಬಿಡ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ದಟ್ ಈಸ್ ಇಸ್ ಕಂಟೆನ್ಷನ್. ಅದನ್ನ ಮುಂಚೆ ಹೇಳಲಿಕ್ಕೆ ಅವರಿಗೆ ನೀವು ರಿಲೀಸ್ ಡೇಟ್ ಅನ್ನೋದೊಂದು ಕಂಟೆನ್ಷನ್ ತಗೊಳ್ತೀರಿ ಅಂತ ಕನಸು ಬಿದ್ದಿತ್ತೆ.
If he is so fair enough to come before the court, it is not the duty of the plaintiff to say that I went to the sub-registrar but I did not know.
ಸರ್, ನೀವು ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಆಫೀಸಿಗೆ ಈ ಪಾರ್ಟಿಷನ್ ಕುರಿತಂತೆ, ಈ ಒಂದು ರಿಲೀಸ್ ಡೇಟ್ ಕುರಿತಂತೆ ತಗೊಂಡು ಹೋಗಿದ್ದೀರಿ ಅಂತ ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ ಅನ್ನೋದೇ ಅವ್ರ ಕಂಟೆನ್ಷನ್.
ಅದನ್ನ ಎಲ್ಲೂ
ಗೊತ್ತಿದ್ರೆ ಅವ್ರು ಡೆಫಿನೆಟ್ಲಿ ಹೇಳ್ತಿದ್ರು, ನನ್ನನ್ನ ಬಾರ್ ಅಂಡ್ ರೆಸ್ಟೋರೆಂಟ್ ಕರ್ಕೊಂಡೋಗಿ 3 ಪೆಗ್ ಹಾಕ್ಸಿ ಇದಕ್ಕೆ ಸಿಗ್ನೇಚರ್ ತಗೊಂಡ್ರು ಅಂತಿದ್ರೆ, ಯಾವ್ದಕ್ಕೆ ಸಿಗ್ನೇಚರ್ ತಗೊಂಡಿದ್ದಾರೆ ಅಂತ ಗೊತ್ತಿಲ್ಲದೆ ಇದ್ರೆ ಅವ್ರು ನನ್ನ ಬಾರ್ ಅಂಡ್ ರೆಸ್ಟೋರೆಂಟ್ ತಗೊಂಡು ಹೋದ್ರು, ಬಾರ್ಬರ್ ಶಾಪಿಗೆ ಕರ್ಕೊಂಡು ಹೋದ್ರು, ಹೋಟ್ಲಿಗೆ ಕರ್ಕೊಂಡು ಹೋದ್ರು, ಇನ್ಯಾರನ್ನ ಕರ್ಕೊಂಡೋಗಿ ಒಬ್ರು ಪಕ್ಕದಲ್ಲಿ ಕೂರಿಸ್ಕೊಂಡು ನನಗೆ ಯಾಮಾರಿಸಿ ಸಿಗ್ನೇಚರ್ ತಗೊಂಡ್ರು, ಅವ್ರ ಕಲ್ಪನೆಗೆ ಬರೋಲ್ಲ. ಯಾಕೆ ಅಂದ್ರೆ ಅದ್ ಯಾವುದು ಅವಾಗ ರೆಲೆವೆಂಟ್ ಅಂತ ಅನ್ಸಲ್ಲ. ರೆಲೆವೆಂಟ್ ಅಂತ ಯಾವಾಗ ಅನ್ಸುತ್ತೆ ಅವರಿಗೆ, ನಿಮ್ಮ ಪ್ಲೀಡಿಂಗ್ ನೋಡಿದ ನಂತರ, ನಿಮ್ಮ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ನೋಡಿದ ನಂತರವಷ್ಟೇ, ಓಹೋ ನನ್ನ ಇವ್ರು ಅವತ್ತು ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಆಫೀಸ್ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದು ಈ ಕಿತಾಪತಿ ಮಾಡ್ಲಿಕ್ಕೆ, ನನಗೆ ಗೊತ್ತೇ ಇರ್ಲಿಲ್ಲ. ಏನೋ ಪಾಪ ಅಪ್ಪ ಕರ್ಕೊಂಡು ಹೋದ್ರು ಹೋದೆ, ತಮ್ಮ ಕರ್ಕೊಂಡು ಹೋದೆ, ತಂಗಿಯಂದ್ರು ಕರೆದ್ರು ಹೋದೆ ಅಂತ ಹೇಳಿ ನಾನು ಅಪ್ಪನ ಮೇಲೆ ಪಿತೃಭಕ್ತಿಯಿಂದ, ಸಹೋದರ ಸಹೋದರಿ ಭಾತೃ ವಾತ್ಸಲ್ಯದಿಂದ ನಾನು ಹೋದ್ರೆ ಇವರಲ್ಲಿ ನನ್ನನ್ನ ಹೀಗೆ ಮಾಡಿದ್ರು, ನನ್ ಮುಂದ ಮೋಚಿದ್ರು ಅಂತ ಅವರಿಗೆ ಗೊತ್ತಾಗಿದ್ದು ನಿಮ್ಮ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ನೋಡಿದ ನಂತರವಷ್ಟೇ. ಹಾಗಾಗಿ ಅವ್ರು ಹೇಳ್ಬಹುದಿತ್ತು ಅನ್ನುವ ಪ್ರಶ್ನೆ ಬರಲ್ಲ, ಅಲ್ಲಿವರೆಗೂ ಅವ್ರ ಕಲ್ಪನೆನೇ ಬರಲ್ಲ.
Whatever he does, with a good intention, if he says that, Lord, I have gone to this office, but I did not know anything.
ಈಗ ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಆಫೀಸಿಗೆ ಹೋಗಿದ್ದೇನೆ ಅಂತ ಹೇಳಿದ್ದಾರಲ್ಲ ಅವರು ಪ್ರಪೋಸಲ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಲ್ಲಿ. ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಆಫೀಸಿಗೆ ಹೋಗ್ಲೇ ಇಲ್ಲ, ಸುಳ್ಳು ಅಂತ ಹೇಳಿದ್ದಾರ ಅವರು. ಇಲ್ಲ, ಅವ್ರದ್ದು ಪ್ರಪೋಸಲ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಓದಿ ತಾವು ಬಹುಶಃ ಮಿಸ್ಕಾನ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ ಅಂತ ನನ್ಗೆ ಅನುಮಾನ ಬರ್ತಿದೆ. 36 ಪೇಜ್ ನಂಬರ್ ಬಹುಶಃ ರಾಂಗ್ ಹೇಳ್ತಿದ್ದೀರಾ ಅಂತ ಅವಾಗಿಂದ. ಪೇಜ್ ನಂಬರ್ 42 ಅನೆಕ್ಷರ್ ಡಿ. ಪ್ಲೀಸ್.
Further submit that the plaintiff has not executed any release date in favor of any family member. In fact, on 5/9/2012, the defendant 124, who are my family members, has brought the plaintiff to the office of the sub-registrar Basanbudi Bank, and they have told that assured me that they are going to allot his share in the suit scheduled property to the plaintiff. Hence, the plaintiff went to the sub-registrar office and taken a photo by putting a signature, but the defendants are not permitted to write which document exactly is going to.
ಅಂದ್ರೆ ನೀವು ನಿಮ್ಮ ಬರ್ಡನ್ ಆಫ್ ಪ್ರೂಫ್ ನ ಅರ್ಧ ರೆಡ್ಯೂಸ್ ಮಾಡ್ಲಿಲ್ವ ಅವ್ರ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಲ್ಲಿ? ನೀವ್ಯಾಕೆ ಅದನ್ನ ಎನ್ಕ್ಯಾಶ್ ಮಾಡ್ಕೊಳ್ಬಾರ್ದು?
ನೆಕ್ಸ್ಟ್ ಪಾಯಿಂಟ್
ಸರ್, ಬುದ್ಧಿವಂತರಾದ್ರೆ ಇಂಟು ಆರ್ಡರ್ ಚಾಲೆಂಜೇ ಮಾಡಲ್ಲ. ನಿಮ್ಮ ಬರ್ಡನ್ ಅರ್ಧ ರೆಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
ಆಲ್ರೆಡಿ
I had been to sub-registrar office. You need not prove. Plaintiff had come to sub-registrar office. Plaintiff has signed this document. You need not prove. He himself in his pleading has admitted it. The sub-registrar office, my photo was taken. You need not prove. He himself has proved. Sub-registrar office ಹೋಗಿದ್ದೆ, ನನ್ನ ಫೋಟೋ ಸಬ್-ರಿಜಿಸ್ಟ್ರಾರ್ ಆಫೀಸ್ ಅಲ್ಲಿ ತೆಗೆದ್ರು, ನಾನ್ ಸೈನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹೇಳಿದ್ರು, ನಾನ್ ಸೈನ್ ಮಾಡಿದ್ದೇನೆ. ಅಷ್ಟು ಆಯ್ತು ಪ್ರೂಫ್. ನಾಳೆ ಸೆಕ್ಷನ್ 45 ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್ ಅಪ್ಲಿಕೇಶನ್ ಅವ್ರು ಹಾಕ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. ಹಾಕಿದ್ರೆ ಅವ್ರದೇ ಪ್ಲೀಡಿಂಗ್ ನಲ್ಲಿಯೇ ನೀವು ಒಂದೇ ಸೆಂಟೆನ್ಸ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡಿ ಕಿತ್ತಾಕ್ಬಹುದು. 85% ಆಫ್ ಯುವರ್ ಬರ್ಡನ್ ಆಫ್ ಪ್ರೂವಿಂಗ್ ದ ಅಲಿಜೆಡ್ ರಿಲೀಸ್ ಡೇಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಡಿಸ್ಚಾರ್ಜ್ಡ್ ಬೈ ಹಿಮ್ ಇನ್ ದಿಸ್ ಪ್ಲೀಡಿಂಗ್. ಸಬ್-ರಿಜಿಸ್ಟ್ರಾರ್ ಆಫೀಸ್ ಅಲ್ಲಿ ನನಗೆ ಸುಳ್ಳು ಹೇಳಿ ನಿನಗೇನೋ ಬೇರೆ ಪ್ರಾಪರ್ಟಿ ಕೊಡ್ತೇನೆ ಅಂತ ಹೇಳಿ ಸಿಗ್ನೇಚರ್ ತಗೊಂಡ್ರು ಅಂತಿರೋದ್ರಿಂದ ಓನಸ್ ಶಿಫ್ಟ್ಸ್ ಅಪಾನ್ ಹಿಮ್. ನೀವ್ ಯಾಕೆ ಇದನ್ನ ಖರ್ಚು ಮಾಡಿ ಕ್ಲೈಂಟ್ ಹತ್ರ ಖರ್ಚು ಮಾಡಿಸಿ ನಿಮ್ ಫೀಸ್ ತಗೊಂಡು ನೀವು ತಲೆ ಕೆಡಿಸ್ಕೊಂಡು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ? ಖುಷಿಯಿಂದ ನಂದಿನಿ ಪೇಡ ಅವ್ರಿಗೆ ಹಂಚಿ, ಅಯ್ಯ ಹೋಗಯ್ಯ ನಿಮ್ ವಕೀಲರಿಗೆ ಹೇಳ, ಅವ್ರ ಭಾಳ ಅರ್ಧ ಕಡಿಮೆ ಆಗಿದೆ ಅಂದ್ರೆ ಸಾಕಲ್ವೇ ನಿಮಗೆ?
the amount which has been paid also has been disputed by 3,50,000 has been.
Yes, take down. ಇಲ್ಲಿ ನಾನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಹೇಳಬಲ್ಲೆ, ಕ್ಲಾಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. 12 ವರ್ಷ ಮಾಡಿದ್ದೇನೆ ನಾನು.
May I submit one more point? ಅಲ್ಲ,
ಬೇಡ.
2012 ಸೂಟ್ ಒಂದು 3-4 months ಅಲ್ಲಿ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ತಾರೆ.
ನಿಮ್ಮ ಕಕ್ಷಿದಾರರು ಬದುಕಿರ್ತಾರೆ ತಾನೆ ಜಾಸ್ತಿ ಸಮಯ? ಬಿಡಿ, ಯೋಚನೆ ಬಿಡಿ.
ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತದೆ.
ಇಲ್ಲಿ ನಮ್ಮಲ್ಲಿ ಕೆಲವು ವಕೀಲರು ಇದ್ದಾರೆ, ಸಣ್ಣ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಕ್ಯೂರ್ ಮಾಡ್ಲಿಕ್ಕೆ 6 ವರ್ಷ 8 ವರ್ಷ ತಗೊಳ್ತಾರೆ. ಮೊನ್ನೆ ನಾನು ಇಂಡಿಪೆಂಡೆಂಟ್ ಡೇ ಸ್ಪೀಚ್ ನಲ್ಲಿ ನಾನು ಅದನ್ನೇ ಹೇಳಿದೆ. 13 ವರ್ಷದಿಂದ ಒಂದು ಮ್ಯಾಟ್ರು ಟು ಕಂಪ್ಲೈ ದಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅನ್ನೋದಿತ್ತು. ನಾನು ಅದನ್ನು ಪಬ್ಲಿಕ್ ನಲ್ಲಿ ಹೇಳಿದ್ರ ಮೇಲೆ ಅದನ್ನ ಸ್ವಲ್ಪ ಮುತುರ್ಜಿ ತಗೊಂಡು ಏನೋ ಮಾಡಿ ಬೇಗ ಮುಗಿಸಿದ್ರು. ಅಂತದ್ದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಮಾಡ್ಲಿಕ್ಕೆ ಅಷ್ಟು ದೀರ್ಘಾವಧಿ, ರಾಮನ ವನವಾಸನೋ ಅಥವಾ ಪಾಂಡವರ ಅಜ್ಞಾತವಾಸದ ಅವಧಿನೂ ಮೀರಷ್ಟು ತಗೊಳ್ಬೇಕಾದ್ರೆ ಇಲ್ಲಿ ನಿಮ್ಮದೊಂದು ಸೂಟಿಗೆ ನೀವಷ್ಟು ಅರ್ಜೆಂಟ್ ಮಾಡಿದ್ರೆ ಹೇಗೆ ವಕೀಲ್ರೆ?
ವರ್ಷ ಆಯ್ತಲ್ಲ, ಅಟ್ಲೀಸ್ಟ್ ಒಂದ್ ಸ್ವಲ್ಪ
ನೋಡಿ, ಅಪ್ಪ ಮಕ್ಕಳಿಗೆ ತಾನಾಗಿನೇ ಜ್ಞಾನೋದಯ ಉಂಟಾಗಿ ಒಟ್ಟಾದ್ರೆ ಚಂದ. ಇಲ್ಲಿದ್ರೆ ಹೊಡೆದಾಡ್ತಿದ್ರೆ ಇಬ್ರು 2 ಹೊತ್ತಿನ ಊಟ ಸೇರುತ್ತೆ. ಇಲ್ದ ಹೋದ್ರೆ ಇವತ್ತು ಏನು ಆಯ್ತು, ನನ್ನ ಮಗನ್ ನಾನು ಬೈಕಳ್ಳ ಇಲ್ಲ, ಇವತ್ತು ಯಾಕೋ ಗೊಜ್ಜು ಸರಿ ಹೋಗ್ಲಿಲ್ಲ ಅಂತ ಅಪ್ಪ ಅನ್ಕೊಳ್ಳೋದು. ನಮ್ಮಪ್ಪನ್ ನಾನು ಬೈಲೇ ಇಲ್ಲ, ಇದ್ರೆ ನನ್ನ ಫ್ರೆಂಡ್ ಎದುರು ನಮ್ಮಪ್ಪನ್ ಬೈದ್ರೆ ನಾನು ಇನ್ನೊಂದು ಪೆಗ್ ಜಾಸ್ತಿ ಹಾಕ್ಬೇಕಿತ್ತು, ಇವತ್ತು ಯಾಕೋ ಡೇ ಸರಿ ಹೋಗ್ಲಿಲ್ಲ ಅಂತ ಮಗ ಅನ್ಕೊಳ್ಳೋದು ಆಗ್ತದೆ. ಬೇಡ, ಇಬ್ರು ಪರಸ್ಪರ ಚೆನ್ನಾಗಿ ಬೈದಾಡ್ಕೊಂಡಿರ್ಲಿ, ಇಬ್ರು ಹೆಲ್ತ್ ಚೆನ್ನಾಗಿರ್ತದೆ, ಯಾರಿಗೂ ಬೇಗ ಏನೂ ಆಗಲ್ಲ. ಕುಟುಂಬದವ್ರನ್ನ ಬೈದಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅಂದ್ರೆ ಅವ್ರು ಸಾವು ಅವ್ರ ಹತ್ರ ಬರಲ್ಲ, ಅವ್ರು ದೀರ್ಘಾವಧಿ ಇರ್ತಾರೆ.
ಅದೊಂದು ಡೈರೆಕ್ಷನ್.
The present petitioner was defendant number 1 in OS number so and so, filed against him and respondent number 2 to 7 herein by the present respondent number 1 in the court of so and so for the relief of partition and a declaration. After the pleadings, the plaintiff has come up with I and Order 6 Rule 17, taking permission to amend his plaint by incorporation of paragraph number 10A. After inviting objection and hearing both sides, the trial court proceeded to allow the said application under the impugned order dated 8/8/2017. Challenging the same, the defendant number 1 in the trial court, who is the petitioner, defendant number 1 in the trial court has preferred this writ petition. The respondent, though served, has remained. The respondent number 1 is appearing through his counsel. The remaining respondent, those served, have remained absent. Even the learned counsel for respondent number 1 also since has remained absent on several dates of hearing. This court in its order dated 15/3/2022 made it clear to the respondent number 1 that in case if he fails to appear on the next date of hearing and proceed further in the matter, the court may proceed to hear the petitioner and proceed further in the matter. Still, the learned counsel for the respondent number 1 remained absent, showing no reasons for his non-appearance. As such, the court proceeded to hear the argument of learned counsel for the petitioner. The learned counsel for the petitioner submitted that the proposed amendment is an afterthought of the plaintiff to cover up loopholes in his pleading. At the time of instituting the suit itself, the plaintiff could have mentioned about the alleged development, mentioned about the development that had taken place on 5/9/2022 and execution of the relinquishment, execution of the release date. You could have stated that he has not executed any such deed. However, it is only after the defendants filed the written statement he has come up with the said application. But the trial court, without noticing the said aspect, has allowed the said application filed by the plaintiff, which warrant interference at the hands of this court. A perusal of the pleadings, the certified copies of a perusal of the pleadings, the copies of which are produced with this memorandum of petition would go to show that in his plaint, the plaintiff has not stated about the alleged development which is said to have taken place on 5/9/2012. It is only after the defendant filing the written statement where they contended that on 5/9/2012, the plaintiff by himself coming to the office of the sub-registrar has executed a release date, relinquishing, releasing his right in the suit property in return of a consideration of ₹3,50,000, the plaintiff has filed the application seeking permission to amend his plaint. In the proposed amendment, the plaintiff has stated that he did not know as to for what purpose he was taken to the sub-registrar office on 5/9/2012. However, he was made to go to the said office and put his signature on some documents, believing the assurance of his father and siblings that they would allot his share in the property. He has signed those documents. When it is the contention of the plaintiff that he did not know as to why he was made to go to the sub-registrar office on 5/9/2012, it cannot be expected of him that at the earliest point of time he should think and decide that his alleged visit to sub-registrar office on 5/9/2012 has got some bearing to his suit, and as such he should mention about the same. On the other hand, it is only after he is said to have coming to know the purpose of his visit to sub-registrar office on 5/9/2012 through the written statement filed by the defendant. He has given the explanation as to what has happened on the said day. Though the said explanation, the plaintiff could have been placed on the record, not necessarily under Order 6, Rule 17 CPC, but under other relevant provision of CPC, including under Order 8. However, he has chosen to bring it under Order 6, Rule 17 CPC. Since in the proposed amendment, he himself has stated that he had been to office of the sub-registrar on 5/9/2012 and was made to execute some documents. Probably some portion of the burden of the plaintiff to prove the issue, which is said to have been cast in the matter, placing the cast in the matter about proving the alleged release deed by the plaintiff, appears to have been reduced. Thus, since the plaintiff has given reason for not placing the proposed amendment as the original part of his claim, and the proposed amendment would in no manner either alter or change the nature of the case, nor even causes any prejudice to the interest of the defendants, and nor even affect the alleged rights of the defendants, if any, in the suit, provided already accrued in their favor, if any. I do not find any reason for interfering in the impugned order. Accordingly, the writ petition stands dismissed as devoid of merit. Next line. Since the original suit is said to be of the year 2013, the early disposal of the matter by the trial court is appreciated. Defendant's burden, plaintiff's burden, defendant's burden to prove the relinquishment deed. Okay.
47. Ekta Pradhan for the petitioner, H.V. Devaraj for Arun and Arto, B.M. Prakash for R3.
May I please, my lords? I appear for the petitioner. May I please, my lords? I appear for the petitioner, my lords.
There are counsel from both sides present. Who appears for R3? I will grant you time by imposing cost. Otherwise, your name would be deleted and I appoint amicus curiae or respondent number 3 remains unrepresented. No, it is say the conduct of the counsel. When I grant time to him, I can equally easily grant time to you also. But with all fairness, he prayed for time to file wakalat. You also stand in the equal footing. Earlier to him, you have undertaken to file wakalat. He came subsequently on record in the place of another counsel. But much prior to him, you were already had taken notice, but till date you have not filed wakalat. But still you kept quiet, thinking that anyhow he has prayed time. If the court grant time, equally I to get a time. Sir, this is what I very much dislike. You have to file wakalat for R2, right? ಎಲ್ಲ ಆದ್ರೆ ಹಾಗೆ ವಕೀಲ್. Who appears for petitioner?
I do, my lords. I appear for the petitioner.
How about you taking emergent notice to respondent number 3?
Please, my lords, I'll do that.
The counsel is not filing wakalat.
I'll
Since
do that.
9 months he has not filed wakalat.
I'll take out emergent notice.
Counsel for the petitioner is appearing to video conference. Counsel for respondent number 1 and 2 is physically present. Since learned counsel Shri V.N. Prakash has not filed wakalat even after accepting the notice for respondent number 3, the petitioner to take emergent notice upon respondent number 3. The petitioner to pay the necessary process and furnish copies in the registry within a day from today. In the meantime, respondent number 1 and 2, if not already filed their statement of objection, to file the same. List the matter on 11/4. Yes.
You're obliged, my lord.
Number 48, Sri A. Gopi Prakash for the petitioner, SCP for 93, J.R. Anantram.
Yes, when shall we have it?
Yesterday would be my request.
That would be in the first week of April.
The request is if it can be accommodated sometime during this month, my lord.
30th, 31st.
My senior counsel ಕೇಳ್ತಿದ್ದಾರೆ 31st it is convenient for amendment.
31st.
31st is all.
Lord counsel for the petitioner, respondent number 1 to 7 are physically present. Since the court time is over, list this matter on 31/3/2020. Sorry, wait.
Just the next matter, shall I request it to be taken up tomorrow, please, do not. 49.
Who is on the other side? ನಾಳೆ ಸ್ವಲ್ಪ ಡೌಟ್ ಲಿಸ್ಟ್ ಆಗಿರ್ತದೆ, ನಾಡಿದ್ದು ಹಾಕೊಳ್ಳೋಣವೇ?
Please, Manoj. 25th it could be.
ನಾಡಿದ್ದು ಅಂದ್ರೆ ಯಾವಾಗ ಬರುತ್ತೆ? ಅದು 20, 23, 24, 25 ಫ್ರೈಡೆ.
Please, Manoj.
Yes. Let senior counsel for. Yes, please. Some family ಯಾಕ್ರಿ? ನಿಮ್ ಫ್ಯಾಮಿಲಿ ಇದ್ರೆ ಹೇಳ್ರಿ. ಯಾತಕ್ಕೆ ನೀವು ಬೇರೆಯವ್ರ ಕುಟುಂಬಕ್ಕೆ ಇಂಟರ್ಫೇರ್ ಆಗ್ತಾರೆ? Learned counsel intend to interfere in some family on 25th. ಬೇರೆ ಡೇಟ್ ಇದ್ರೆ ಕೊಡಿ.
First or second it could be taken up.
Yes. April 1st ಆಗಬಹುದೇ? Truly, the matter would be coming on April 1st. Learned senior counsel ಹೇಳ್ತಿದ್ದಾರೆ ಫಸ್ಟ್ ಏಪ್ರಿಲ್ ಅಂತ. ಒಂದು
ಸೆಕೆಂಡ್ ಹಾಕಿ, ಸೆಕೆಂಡಿಗೆ ಫಸ್ಟ್ ಬೇಡ, ಸೆಕೆಂಡ್ಗೆ ಹಾಕಿ.
ಸೆಕೆಂಡ್ ಸೀಟಿಂಗ್ ಇದೆಯೇನ್ರಿ? ಇಲ್ಲ,
ಸೆಕೆಂಡ್ ಇಲ್ಲ,
ಸೆಕೆಂಡ್ ಶನಿವಾರ ಬರ್ತದಲ್ಲ ವಕೀಲ್.
ಫೋರ್ತ್ಗೆ
ಸ್ಪೆಷಲ್ ಸಿಟ್ಟಿಂಗ್ ಇಲ್ಲ ಅನ್ಸುತ್ತೆ ಆ ಶನಿವಾರ.
ಫೋರ್ತ್ಗೆ
ಕೊಡಬಲ್ಲೆ.
ಫೋರ್ತ್ಗೆ
4th 3 ಪಾರ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಇದೆ.
ಹಾಗಿದ್ರೆ leave it to the court, please.
ಅಲ್ಲ, ಅವ್ರು 31st ಕೇಳ್ತಿದ್ದಾರೆ. ನಿಮ್ಗೆ 31st ತೊಂದರೆ ಇಲ್ಲ ಅಂದ್ರೆ ಕೊಡಬಲ್ಲೆ.
31st 31st ನಮಗೂ
ಏಪ್ರಿಲ್ ಫಸ್ಟ್ ಕೊಡಬಲ್ಲೆ. ಏಪ್ರಿಲ್ ಫಸ್ಟ್ ಸಿಟ್ಟಿಂಗ್ ಅಂತೂ ಇರುತ್ತೆ. ನಾನು ಇರ್ತೇನೆ, ಭಗವಂತ ನಡೆಸಿ ಕೊಟ್ರೆ.
4th ಗೆ ನಾನು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊತಾ ಇದ್ದೀನಿ. 4th ಕೊಟ್ರೆ ಮಾಡಿ
ಕೊಡುವ. ನೋಡಿ, ನೀವು ತೀರ ಅಷ್ಟು ಆ ಕಡೆ ಈ ಕಡೆ ಹಗ್ಗ ಜಗ್ಗಾಟ ಆಗಿರ್ಬಾರ್ದು. ಲರ್ನೆಡ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಒಬ್ರು 1, 2, 3 ತಾರೀಕು ಕೊಟ್ರು ಅಂತ ಹೇಳಿದ್ರೆ ನಿಮ್ಮ ಅನುಕೂಲದ್ದು. ನೀವು ಅದು ಯಾವ್ದು ಬೇಡ ಅಂದ್ರೆ ಹೇಗೆ? Learned senior counsel for the petitioner and learned counsel for respondent 1 are present. Since the court time is over, the matter could not be taken up today. This matter on 1/4/2000. ಅದೆಲ್ಲ ಆಗಿದೆ ರೀ ಮ್ಯಾಟರ್ ಅದು. ಹೌದು. ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿಲ್ಲ ಅದು. ಹೌದು, ಆಗ್ಲಿಲ್ಲ. ಇವತ್ತಾಗ್ಲಿಲ್ಲ ರೀ. ಅದು ಸುಮಾರಷ್ಟು ಆರ್ಡರ್ ಶೀಟ್ಗಳು ಸೈನು ಆಗಿದೆ. ಇದು ಯಾವಾಗ ಕರೆದದ್ದು? ಈಗ ತಗೊಂಡಿದ್ದೀರೇನ್ರಿ ಮ್ಯಾಟರ್? ಅದು ಪ್ರೀವಿಯಸ್ ಆರ್ಡರ್ ಶೀಟ್ ತೆಗೀರಿ. ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟಂದ್ರಿ? 41 ಫೈಲು ಹೋಗಿದೆ. ಅದ್ರಲ್ಲಿ ಇಂಟೀರಿಯರ್ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಲಿಲ್ಲ. ಅದಾಗ್ಲಿಕ್ಕೆ ಬರೋದು ಇಲ್ಲ. ಅದು ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ. ಆದ್ರೆ
My lord, serial number 52, my lord.
Yes.
In this, cause list says that the government advocate has not filed the memo of appearance, my lord.
They won't file it.
No, it has been filed, my lord. On 14/3/2022, the memo of appearance has been filed.
Whom you appear for?
Please, my lord.
Whom you appear for in that matter?
My lord, I appear for the excise department.
No, respondent, right?
Yes, respondent.
You are the government advocate, right?
Please, my lord.
Yes, tell that. Say, I am the government advocate. I have filed memo of appearance.
Please, I have filed as on 14/3/2022.
Learned AGA for the respondent submits that she has filed memo of appearance on which date?
Filed on 14/3 and the seal was on 15th March 2022, my lord.
15/3/2022. However, still the registry is showing the cause list that MA is not filed. It appears that there is a memo of appearance dated 14/3/2022 in the record, filed on 15/3/2022. Learned Registrar Judicial to give proper instruction, appropriate instruction to the concerned, not to appropriate instruction to the concerned in this regard. ಅಷ್ಟೇ. ಏನ್ರಿ ಇದ್ರಲ್ಲಿ ನಿಮ್ಮದೇನ್ ಹೇಳಿದೀರಿ ಏನ್ರಿ? ಇನ್ನು ತಗೊಳ್ಳಿ ಅಂದ್ರೆ ತಗೊಳ್ಳಲ್ಲ. ನಾ ತಗೊಳ್ಳಿ ಕೂತ್ರೆ ಇವರಿಬ್ರು ಸೇರಿ ನಾನು ಹೊತ್ತಾಗ್ತಾರೆ ಹೊರಗಡೆಗೆ. ಐ ಆಮ್ ರೆಡಿ ಟು ಸಿಟ್. ಅದ್ರಲ್ಲಿ ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ಪೆಟಿಷನ್ ಪ್ರೆಸೆಂಟ್ ಅಂತಾನು ತಗೊಳ್ಳಿ. ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಇನ್ ದ ನೆಕ್ಸ್ಟ್ ವೀಕ್. That is over in the morning itself. Order sheets are signed.